I lost my coffee, but I'm ready to go. You know what time it is. Time for Monday Morning with Mo. Good morning, everybody. Welcome to another episode of Monday Morning with Mo. We are still over here in the Bahamas, and it is the week of Christmas. So I hope everyone's gets a short week and maybe spend some time with some family if you can do that. As always, we're here every Monday morning at 8 a.m. to answer your legal questions. I am in vacation mode today, so I have a little vacation beard going on. I hope you guys don't mind. And I have no idea why that boat video is upside down, but that's how things roll sometimes. So, anyways, as always, any legal questions, give us a call 407 536 6737, or you can shoot us an email, askask@law.com. So, we'll jump right into it this morning. First up, we have a voicemail here, so let's go ahead and play that.
Yes, I was wondering if Moses could delineate what no-fault insurance means. I always thought it meant that each party was equally to blame, but my wife was recently hit by a driver, and police reported there was no injury, luckily, but his company was assigned the risk and had to pay for the damages as if he was at fault. So I'm trying to figure out if the no-fault just applies to a particular type of incident. Thank you so much. Bye.
So, that seems to be a common misconception. So, in Florida, we have no fault insurance, or PIP insurance, personal injury protection insurance. And so that's up to $10,000 in benefits for you to go get medical treatment, whether you're at fault or not. That's why it's called no fault insurance, because you can use those benefits whether you're at fault for the accident or you're not at fault for the accident. So, the good part is even if you're at fault and you're injured, you still have some benefits there. But in Florida, you can still sue or go after, or the person who's responsible for the accident can still be liable for the accident. And as we know, $10,000 in benefits, one trip to the ER is pretty much going to eat those up, which is why I always recommend having uninsured motorist coverage, UM coverage on your policy. Because what happened is why we have no fault insurance, the $10,000 in benefits. We have that because there was a negotiation in the legislature a number of years ago where basically they made the $10,000 no fault benefits mandatory, but bodily injury coverage is not mandatory. So what that means is that someone can hit you and hurt you, and they don't have to have insurance to cover it. You just have those no fault benefits, which is why uninsured motorist coverage is so important in Florida, because that basically steps into the shoes of the at-fault driver. We've talked about it many times, but it steps into the shoes of the at-fault driver. So it covers you if someone hits you and hurts you and doesn't have proper insurance for compensation. And as we know, medical bills can pretty easily exceed those $10,000 in benefits. So great question. Always appreciate the questions. Keep them coming. Leave those voicemails, 407 536 6737, or shoot us an email, askask@whitlaw.com. Probably a little shorter show this morning since it is Christmas week. It's a short week. Only got a couple questions here this week. So next up is James. James asks, can Florida Medicaid recipients sue for malpractice to your knowledge? So, pretty simply, it doesn't matter whether you're on Medicaid or private health insurance or paying cash for the procedure. Any doctor, if they deviate from the expected standard of care within that community, they can be sued for malpractice. So, the one thing about malpractice is typically there has to be pretty significant injuries. In Florida, we have a pre-suit malpractice statute that basically requires you to go out and hire a doctor who's an expert in that field. Let's say it's orthopedics, it has to do with a broken bone or a hip surgery or something like that. You need to hire a doctor who's an expert in that field, who has to then sign an affidavit saying that the doctor who did the procedure deviated from the standard of care. So the purpose of that was for less malpractice lawsuits to be brought. It also makes it more expensive for malpractice lawsuits to be brought. And so therefore, typically, when you're looking at a malpractice case, there really has to be significant injuries in order to make it worthwhile. And not just worthwhile to the attorney, but worthwhile to the client, because usually with a medical malpractice case, we may be paying the doctor $5,000 or $10,000 to review the file even before we're filing suit, to go ahead and sign that affidavit if he finds there was malpractice. And if he doesn't, then we're just out the $5,000 or $10,000. So That's why those cases can get quite expensive, is because you're having to retain and pay a lot of experts on them, basically to testify how malpractice was committed in those cases. So, it doesn't make a difference if it was if Medicaid was paying the bill or Medicare was paying the bill. If the doctor deviated from the standard of care, then you could still have a malpractice claim on your hands. So, thank you for your question, James. And as always, if you guys have any legal questions out there, shoot us an email, ask@ask@dwitlaw.com. Get a little water there. Or you can leave us a voicemail, 407-536-6737. Also translates to 407-53 Moses. So yeah, leave us a voicemail. Having legal questions, that's what we're here for. Every Monday morning at 8 a.m. So last up is Jamarius. Jamarius says, I was recently in an accident, and after the accident, the driver got out of his car and punched me in the face. I wasn't injured from the accident, but will his insurance company cover the damage that was caused by him punching me? So, typically, if someone punches you like that, that's what we call an intentional tort. And most insurance policies have an exclusion to where intentional torts are not covered. So, common examples of that are fights, brawls, someone punching you. Usually, unless it's within a certain exception, it's not going to be covered by the insurance, because insurance companies do not cover intentional torts. However, in this case, if you were injured from the accident, I know in this case, Jamaris' case, it wasn't, but if this ever happens to you, this is what we call an aggravating factor. So the insurance company is not going to want to hear this. They're not going to like it. A jury's certainly not going to like it if the case were to go to trial. So it's an aggravating factor that's going to make the defendant in this case not look very good in the light of the jury, if this case ever made it to trial. So Jamarius probably doesn't really have a case because he wasn't injured in the accident. But if he was, and then someone comes out and they spit in your face or punch you or anything like that, those are all facts that are going to aggravate the situation. And usually that's not going to be bode very well for a defendant in the light of a jury. The jury's not going to like that very much. It's going to make the tort fees are not real favorable to the jury, and the insurance company knows that. So the insurance company is typically probably not going to want to take that case to trial and have that information be presented to the jury. They may try to exclude it, and that's a whole other discussion. But certainly, if you did have a claim, something that you would want to let your attorney know, and let the at-fault driver's insurance company know, because while it's not directly relevant, they won't pay out for those damages necessarily, because it is an intentional tort. There may be some other aggravating factors there. So, thank you as always for all the questions this week, guys. I hope you guys have a great holiday week. I hope you're taking some time off, getting to spend some time with your family, maybe relaxing a little bit. We're spending the Christmas vacation over here in the Bahamas, so we'll be here for a little while longer. But if you do need to reach us at all, you can give us a call, 866-CALL-MO, anytime, day or night. I think I've answered a call at midnight, 2 a.m., and a few other calls during the day while I've been here so far for people who are in car accidents and have some questions. So never hesitate to give us a call. That is what we're here for. And as always, if you have any legal questions, shoot us an email, leave us a voicemail, and we'll see you next week, Monday morning, 8 a.m. for another episode of Monday Morning with Mo. Have a great week, everybody. Take care.